Hello, I'm Justin M. Kennedy, an attorney with Litho and Kennedy and Associates, a California estate planning and elder care law firm. Today I'm going to discuss another advantage of the Family Discretionary Trust. In my previous video, How to Protect the Proceeds of the Sale of a Home for Medi-Cal Eligibility Purposes, I talked about one advantage of the Family Discretionary Trust. I would like to discuss another advantage today. Let me first start by giving context. As an attorney, I am trained to look for loopholes in the law that can benefit my clients. The Family Discretionary Trust is created to fit nicely within one of those loopholes, specifically a loophole around the definition of ownership. Medi-Cal, the California implementation of the federal Medicaid program, and the IRS use two different definitions of ownership. And we have designed the Family Discretionary Trust so that for Medi-Cal eligibility purposes, assets in the Family Discretionary Trust are not owned by the applicant, but for IRS purposes, the assets are still owned by the applicant. Why is that important? Assets owned in the Family Discretionary Trust are ignored for Medi-Cal eligibility purposes. Previously, I showed how this works great if the applicant needs to sell their home, as the sale proceeds would be protected if the home was moved into the Family Discretionary Trust prior to selling. To illustrate why it may be good to keep the home owned by the applicant for IRS purposes, let's imagine the applicant has a home valued at $1 million that they originally bought for $200,000. If the applicant sold the home today, they'd be taxed on the $800,000 of appreciation. This is a capital gain. If the applicant continues to own the home until their death, then the $800,000 of capital gains would be eliminated. This is the step up in basis to fair market value as of the date of death. This means that the home could be sold the day after the applicant's death and there would be no capital gains taxes. If the home was moved into the Family Discretionary Trust and not sold during the applicant's life, then upon the applicant's death, the applicant would still be treated as the owner for IRS purposes, and the capital gains would be eliminated as of the date of death. Because of this result, I have had many clients who do not want to sell the home during the life of the applicant. Yet, if the applicant needs additional income, they may consider renting the home. Without the Family Discretionary Trust, for Medi-Cal purposes, the rental income is treated as income of the applicant and would increase the applicant's share of costs. This could result in the applicant losing money by renting the home. Whereas if the home was moved into the Family Discretionary Trust and then rented, the rental income would not be the applicant's for Medi-Cal purposes and would not increase the applicant's share of costs. This preserves the rental proceeds, and those rental proceeds may be used to give the applicant a better quality of life, paying for things that would not be covered under Medi-Cal. The Family Discretionary Trust preserves the rental money without increasing the applicant's share of cost. It keeps the home exempt, prevents the Medi-Cal estate recovery lien against the assets in the Family Discretionary Trust, and achieves the step up in basis, the elimination of capital gains upon the applicant's death. The Family Discretionary Trust is not for everyone, but for those who need it, it is a great resource.